I wish to concede, Your Worship, at this stage and correct one aspect. I'm not changing the affidavit of the investigating officer, but as a state, I wish to concede that what he says in the affidavit, that there is no extradition treaty with Tanzania, is not correct. Will that be used against him? I'm not sure, but it has not been addressed so far. But nonetheless, whether that treaty exists or not is neither here nor there. The application remains opposed. At paragraph 7.3, the applicant provides this court with family background. Amongst others, she states she has full parental responsibility and specific parental responsibilities and rights of her 2 minor children. These are the children that she left behind when she was kidnapped, and she opted not to open a criminal case against this person. And let's take it further, Your Worship. In her own affidavit, she's telling this court, I am challenging, amongst others, my transportation from Tanzania to South Africa. I'm challenging that in the High Court. Now, let's pause a little bit, Your Worship. She has been taken unlawfully by forced into a car to Tanzania. I quite agree, and I agree with my learned friend, that this matter is still being taken up on further on SCA. But so far we have judgments that remains until SCA changes it. But the point I'm trying to make is, Your Worship, you are taken unlawfully to Tanzania. The South African authority, I don't know who they are, they bring you back to South Africa, amongst others, to be with your children and to practice and go on with your practice as a medical ed. They bring you back to South Africa. And you go and challenge that. You challenge the fact that you were brought back to Tanzania, where you did not want to be. She did not want to be there. She was kidnapped, according to her own evidence. It's a right to challenge whatever action you see. But what does this mean? It means, allow me to remain in Tanzania. That's what it means. And we are told she has no desire whatsoever to leave South Africa and to evade trial. Let me address one aspect that relates to the personal circumstances that are before us. The applicant states that prior to her arrest, she was staying at a particular address, which is 22A 2nd Road, Hyde Park, Sandton. She was arrested on 7 April 2023. Prior to my arrest, Your Worship, I assume it must be prior to 7 April 2023 when she was arrested in Tanzania. Or let's accept, for the purpose of this case, it was on the 13 April 2023 when she was arrested to face this charge. She says, prior to my arrest, that was my address. She does not provide the investigating officer with the address at the time of arrest. And now we hear, and we accept. It's in the investigating officer's affidavit that she was staying in this address, and she left in March 2023, and the investigating officer, I don't want to decorate it, but says unceremoniously vacated the place where he was staying. Your Worship, it's crucial to say, at the time, she still provides the investigating officer with this address, well knowing she's no longer staying there, according to her own evidence. Otherwise, how would the investigating officer have known this address? And now here in court, she provides the court with an alternative address. She does not state in her affidavit that she will be staying. She also provided to the investigating officer at the time of arrest. She does not say so. Why not? And it's her choice, Your Worship, where she wants to stay. It's her choice. But having said, I have siblings, I have parents, why would you want to choose to stay with a friend and not siblings or parents? Now, at the time this address was given in court, the investigating officer, yes, verified, in no space of time, short, I think we adjourned for an hour, which Advocate Dlamini finds offensive, that in short space of time he was able to gather what he has gathered. It simply says how advanced the South African police services are. But the investigating officer, this has not been challenged, even in the address. The investigating officer says, I have established that this is the nationality of this person. He does not end up there. He says, one of the co-accused, accused number 9, is from the same country, the same as this person who she says she will stay with. The investigating officer does not make judgment on this aspect. No. All that he's saying is there in the affidavit. He says it is concerning the ties that she has with this particular country is concerning. He does not make judgment. And yet, he's accused of being xenophobic. What does xenophobia mean? It means a hatred or a dislike of a foreign national. Does the IO say here that he dislikes or hates them? No. All that he's saying is it's concerning that accused 9 has been a gardener and security officer, and now we are giving another person who comes from. That's all that he's saying. He's not passing judgment. It's there in the affidavit. And yet he is accused of being xenophobic. But of importance, Your Worship, of importance, applicant provides this court with an alternative address, granted. The investigating officer states in his affidavit, which is not challenged, in fact, it is commented, said, so it means even after the rental, she was still staying there. That's what Advocate Dlamini specifically said. But the fact of the matter is, there is this previous address. This is the address where she will stay. What does that mean in terms of whether the applicant has a fixed address or not? The fact that he provides an alternative address simply says, as we speak, not tomorrow, not yesterday, as we speak, she has no fixed address. And the investigating officer is saying what? He's saying her relations with these particular nationalities is concerning. And yes, he did not provide a tracker or evidence, but he goes on to say even a Mercedes-Benz that she was rented in her name was found abandoned in that very same country that I don't want to mention. I might be accused of one or other thing, but I'm not mentioning it. But it's there in the affidavit of the investigating officer. So, Your Worship, all that I'm saying to the court up to so far is that the applicant has not satisfied the court in adducing evidence that it is in the interest of justice that she be admitted to bail. And that relates to section 60, subsection 4B, which incorrectly is being said that that's the only ground upon which the investigating officer is opposing bail. Joseph, moving forward, insofar as section 64D, the investigating officer states in his affidavit, there is a likelihood that the applicant, if the objective of the criminal justice system, including the bail system. And when one looks at the grounds, the factors that the court must consider, whether this has been satisfied or established. Question whether the applicant provided false information, issues like that, which we find in the affidavit of the investigating officer. Factly, he says the fact that she provided me with this address, knowing she no longer stays there, she was misleading me. She provided me with false address. And she provides a list of false information that the applicant made not at the time of arrest, but previously when she approached the High Court in Pretoria. In terms of her own affidavit, although the name does not appear, she states that she is married with 2 children. And in the High Court, we know her to be married to Thabo Bester, which is accused number 5. And not only that, the investigating officer states that, amongst others, she says, under oath, which was commissioned before a legal firm of attorneys, that Thabo Bester's mother is deceased. And the investigating officer says, I traced her mother, his mother, and Thabo Bester's mother is alive. And we went further to conduct DNA, which is positive that this is Thabo Bester's mother. If one can deceive the High Court, what more about this court? Can this court really trust and conclude that it is satisfied that the applicant will stand trial, having gone to a high court, to claim a body, claiming that body belongs to someone who we know by now is alive, is accused number 5. He's alive. And the investigating officer not only stops there, she says the applicant has established that the applicant, when claiming this unidentified body, she said it was her father. Can that be true? We know accused number 2 in this matter is her father. And her father is alive. Why would you deceive? And that is the evidence that this investigating officer says we have. In relation to what? To fraud. She goes further than that. This is just trying to show the court that there are factors weighing against the release of the accused, the applicant on bail. According to the investigating officer, even the founding affidavit is there. That was submitted in the High Court in Pretoria. She claimed her father, which is accused too, negotiated lobola, and that 60,000 rands was paid, and therefore the customary marriage was complete, in terms of her own affidavit in the High Court. Who is the father? Accused number 2 in this matter. That the investigating officer also says accompanied the applicant to claim one of the bodies. That's in his affidavit. She goes on to claim that Thabo Bester's uncle by the name of David Magagula is deceased. And the investigating officer says, I have established from one class Magagula that there has never been a David Magagula. Insofar as Section 64E, the investigating officer states in his affidavit the likelihood that the release of the applicant will disturb the public order or undermine the public peace or security. In this regard, we are told that this cannot be correct because her co-accused has been released by the High Court, and there has not been any public outrage. But I wish to state, Your Worship, the conduct and involvement and the role played by the applicant, as outlined by the investigating officer, clearly shows she has no respect for the criminal justice system. She orchestrated the escape of a person convicted of serious offenses and who was locked up at a maximum security prison. It is a demonstration of a disregard for the courts and the law. Let's remember that Thabo Bester was sentenced by a court of law. Then someone went to claim that she is deceased and he wants to cremate her, when in fact Thabo Bester was alive. That is a person who has disregard to the processes that led to the conviction and sentencing of accused number 5. Joseph, the fact that her co-accused have been released, in releasing the court, considered specific personal circumstances and whatever, and the role and everything. It took everything into consideration. The circumstances, the role, and the personal circumstances of the applicant here are quite different from each one of those accused who have been released. Therefore, the court cannot just on that basis say, okay, your co-accused have been released, I therefore also release you. The court must still apply its mind and the court must make a determination whether evidence has been adduced to satisfy itself that this applicant, not the others that have been released, this applicant, it is in the interest of justice to release her on bail. So that comparison, we have not even been told what factors the court considered in releasing them. We are dealing with this evidence before us that relates to the applicant. Your Worship, my written argument, page 9, concludes by making reference to State versus Miselo 2002, 1 SACR 49 Constitutional. See, where the court concluded that the release of applicant will disturb the order or undermine. In that instance, the charge was a mere possession of firearm and attempted murder. Joseph, the court must take the holistic evidence before it. The investigating officer has mentioned in his 5 pages, which are said to be stories, how Thabo Bester, how the orchestration of the escape of Thabo Bester happened, and the fact that he was incarcerated at a maximum prison. And he says in this affidavit, the mastermind was the applicant. So those circumstances, Your Worship, are the reason enough to be saying, with this that is before me, with the fact that a sentenced person for life is released, and the applicant has a role in that, and she even went to Tanzania. None of the other co-accused, there is evidence that they were also kidnapped and taken to Tanzania. That's why I'm saying the considerations and the factors in this case are different from the other co-accused. None of them was there anything said, even when one looked at the judgment of the High Court, that they crossed illegally or unlawfully without passports to any of the countries. Therefore, it is my submission that the court cannot, solely on the basis that the co-accused have been released, therefore, the applicant must be released. Your Worship, the investigating officer, in his affidavit under oath, provide the court with reasons why he believes the bail conditions should not be considered. And he substantiates on that aspect. Your Worship, the very same investigating officer that is being attacked personally and said to be decorating his affidavit mentions a factor which I believe is favoring the applicant. He lists the businesses that the applicant appears as a director. He lists them. In other words, what this means is, he is saying to the worship, amongst others, consider that she has businesses, which therefore I would have expected the applicant to be saying, Your Worship, one of the reasons I asked the court to release me on bail, I need to go and take care of these businesses of mine. But Advocate Dlamini says, so what? And the state is showing the court that their businesses are at different addresses. Indeed. But one wonders, because we are told these are the personal circumstances. He's a medical doctor. One wonders, because that is not being challenged. If she has these businesses that she has interest in, that she appears as a director, why would she not disclose them in her own affidavit? Why conceal that factor? What is the reason? Because, as I said, it should be a factor that works in her favor. But she conceals it, does not refer to it anywhere. Your Worship, insofar as my written address, it is my submission. The investigating officer, the prosecution, the state does not carry the burden of showing or proving to this court that the applicant is not entitled to bail. She must first show the court that this evidence before the court are good enough to admit me to bail. Your Worship, when one looks at the two affidavits, the evidence that is before you, I'm glad that Advocate Dlamini referred to the applicant's affidavit as a simple and straightforward affidavit. That is not what the law requires. It says, adduce evidence, not simple, adduce evidence that will satisfy the court that is in the interest of justice, that she be admitted to bail. On the other hand, the affidavit that is criticized is extensive. And nothing in that affidavit shows, like the impression that Advocate Dlamini gave, that the investigating officer harbors any hatred or whatsoever against the applicant. He simply gives the court what his investigations are, what the charges are, what evidence he has. For instance, he says, I have since established from the bank records of the applicant that she paid 85,000 rand. Now, to accuse number one, the defense is saying, in fact, let me start this way. The court should be mindful of the fact that we are dealing with one accused here, which is applicant number 5. And therefore, the affidavit of the investigating officer and the investigation and the background she gives us about the applicant relates to the applicant only. And therefore, it could not be expected that he goes to an extent even saying what the other accused did. We don't know what the other monies came from and whatever, and we cannot say it here. All that he did, he zoomed into what the applicant only did. There are other amounts. Your Worship, as I indicated, I will also ask the indulgence of the court. There has been so much that I noted from the addresses of the two learned friends, and I request that we adjourn so that I go through and don't waste time in addressing the court on what I have already addressed, just to identify those that I need to touch on. I don't know what time is it. Direct evidence to prove the state's case. We don't need the body, the unidentified body for bail application to be exhibited here. So to ask, where is evidence? Then the aspect that has been raised regarding the period or the length of time that the applicant has been in custody and the chances of the matter being finalized far in the future. Your Worship, in this respect, the applicant had a right to apply for bail from the moment she was arrested. That's what our Constitution states. That's what our Criminal Procedure Act states. And if not at the time of arrest, from the moment she appeared before this court, she had the right to apply for bail. The court record so far will show that she has in the past, up until recently, been reserving that right, and therefore the state cannot be faulted that she has been in custody for so long. She opted not to exercise that right. Then I need to clarify one last aspect where the defense is saying the state says she contacted her children once. This is not in the affidavit of Colonel Flyman. Colonel Flyman specifically says she contacted her husband once, not children. So I needed to just touch on those aspects. Then, Your Worship, that completes my address to you. As pleases.
As the court pleases, Your Worship, indeed, the defense would replicate on some of the factors emanating from the state's submissions. Your Worship, in as far as the first submission is concerned, I wouldn't want to overflog the horse, but I think it's important to drive this point quite succinctly, because this is a salient issue pertaining to the schedule of this offense. Yet my learned colleague's address on this point is to the effect that he's mentioning some doors, some back doors, in terms of the evidence and being selective on how we quoted the count. Count 3 is quite clear. Either way we look at it, it's quite clear. It talks about furtherance of common purpose. That's the first leg of it. It then takes us to the second leg. And the second leg of furtherance of common purpose then deals with monies allegedly paid. Endeavors to locate an amount that informs the schedule to be elevated to Schedule 5 were in vain. Those endeavors were in vain. Nothing in count 3 suggests any amount other than 85,000 rands. No explanation is provided to this court of the omission thereto. No explanation whatsoever, other than the state desperately trying to fix a deficiency which I called an incurable deficiency in their own evidence. State furthermore refers to count 4. And state makes a concession, but throws a caveat to that concession. State says, oh, well and good, count 4 makes reference to accused 1, 3, and 7. But wait a minute, you ought to have read the whole count holistically. Suppose that angle should have been applied. But that argument is defective. It's defective in the following manner. Which of the two different parts of this count would the court follow? Will the court follow that this charge, count 4, relates to 1, 3, and 4, and go further to decide, oh no, let's forget about 1, 3, and 7. This count 4 relates to those other accused, inclusive of accused number 4. On what basis are we calling you to make that determination? Legally so. We are bound by the evidence presented. The state is bound to, parties to proceedings are bound by papers before court. Now, it's inescapable that we will try to correct this. I wouldn't even want to call it an error. It is what it is, evidence. You can't correct it anyhow. It's here with us. So my submissions, Your Worship, is that perhaps if one was to use or steal from the word of my learned colleague, perhaps the door is on the other side, not with the defense. The state is frantically and in desperation trying to push this aspect so as to correct the schedule. And we know the importance of the schedule. And the state is fully aware of the importance of the schedules. Therefore, the state should have been meticulous in ensuring that it places all the allegations pertaining to the count in relation to the applicant. But the state put the point further to say the defense is making a lot of issues around the fact that we didn't place all other counts. Perhaps the state didn't comprehend the argument. The contention has always been that, yes, according to the charge sheet, there are 16 counts at least. But according to this evidence, the evidence says something different. That's what we are saying in relation to the applicant. Count number 14, which the state mentioned as being a count that also deals with corruption in relation to accused number 1 being offered an amount of 105,000. Where is it in the affidavit? Where is it in the evidence? In the absence of that being part of evidence, our argument is the charges in that form, in their current form, do not talk to the evidence. And that's the end of it. And that settles the debate in respect of the schedule of the offense which the accused or the applicant should face. The state bears that on us. And it's our submission that the court should find accordingly. Now, Your Worship, moving on to the next aspect of the state submission. And this now relates to the reliance on Section 64B, particularly attacking the version of the applicant. I see in the state's address, the state is saying, unfortunately, both parties didn't have the benefit to cross-examine and test the veracity of the allegations contained in both affidavits. Perhaps to even correct it a bit, because part of it is correct in that the defense has been denied that benefit, that opportunity to test the veracity of all these allegations. So is the state. But the state had a second bite by responding in their affidavit and making reference to some of the issues pertaining to the allegations by the applicant. Now, a crucial question arises here, Your Worship, in that with the state having the second bite, did the state make an effort to undermine the version that the applicant is bringing to this honorable court? The version to the extent that I did not leave the country on my own volition. I did so involuntarily. Other than to, as I indicated, to insinuate and cast aspersions in terms of the conduct and what could a reasonable person in the circumstances would have done. But we are mindful, Your Worship, of the fact that the applicant has a right, constitutionally protected one, which is quite sacrosanct, a right to remain silent. One can also not ignore the right to be presumed innocent until proven guilty within the context of bail application. So what we have here before this court are two versions which largely have not been tested through cross-examination. now for the state to get into the space of trying to assert their version to being better than the applicant's version, because I wouldn't even say probable. It has not been tested. Which takes us to the very same assertions that the defense put across in respect of the character of bail, which I quoted State versus Philjun to say the principle adopted in that matter was to the effect that we are here in court dealing with a particular proceeding which is sui generis. It's inquisitorial in nature, but has got nothing to do with the determination of guilt or otherwise of the applicant. Nothing. This should not be deemed and seen to be a dress rehearsal of a full-blown criminal trial. Some of the factors, if not all of the factors that are there, which the state comes to this court and make and contend that they were not disputed. They were not disputed. Neither were they rebutted through evidence, through cross-examination. Now, it takes us to the level of the probative value. What is required of us? What this honorable court is impelled to do, which is to attach a particular weight, and legislature is deliberate on this, because we're sitting with an untested evidence. Uncontested, how else would she have contested it? Your Worship, it is my submission, therefore, that we are of the view that the state, in as far as aligning, because my learned colleague aligned with the defense in as far as the legal position, the correct legal position is concerned, which is that this proceeding is not to determine the guilt of the accused. And at the same time, on the same breath, the state produces a whole range of arguments around the guilt of the, or rather, the strength of their case, and all of that. It is our submission, Your Worship, that those arguments, in as far as bail proceedings are concerned, they do not sufficiently cover and satisfy the requirement as enunciated in the provisions of Section 60, subsection 4, A2A. There is reference by the applicant to the fact that other accused were admitted to bail. We need not be selective in terms of how we present arguments. The manner in which we present arguments shouldn't be such that it causes unnecessary confusion by misconstruing the points that we brought forward. The point here was not to come with a comparison of any nature, but to say this fact of the strength of the state's case is the very same fact which the state used to oppose the bail for those who successfully appealed the decision of the court accord. So we are saying that is the basis of us bringing this fact into the space, because this fact, Your Worship, deals with section 60, subsection 6, F, A, G, and H. F, the nature and gravity of the charge on which the accused is to be tried. The nature of the charge is the same. With almost all the co-accused. in this matter. G, the strength of the state's case. That's what they were saying against the three accused. They relied on the very same evidence that they want to use against the applicant is the same evidence they have against the other accused. We cannot identify any distinguishable facts around this issue. They are same in character, and the court should treat them as such. State also makes reference of reliance in terms of Section 64E. Section 64E, the state used the very same reason in that when we facts, it is our submissions, therefore, Your Worship, that provisions of the sections alluded to, Section 64A, have been established by the state. And Your Worship, we should also be careful not to have a situation of creating an animal farm situation where some accused will be treated differently but facing same charges. Accused number 2, for that matter, his bail was not opposed. There are also other accused who came later, whose bail was not opposed. Now, the distinguishing feature which the state relies on heavily is that none of them left the country illegally. And this takes me to the next point. Reason has been advanced by the accused, by the applicant, in respect of circumstances that prevailed, that led to her leaving. This court is not called on to really make a determination of whether is this really plausible, is it viable. This is what the applicant is saying. And the applicant is saying, notwithstanding the fact that I have a right to remain silent, I wish to inform the court how I exited the country. Now, the state seems to be having qualms with this explanation. The state seems to expect the applicant to say more. What more? They are also asking rhetorics. How, when, who. Those are rhetorics. And we are saying, we are mindful of the fact that we have the right to remain silent. We will, at an appropriate time and forum, deal with this issue. But for purposes of this bail, I did not leave voluntarily. But I will take the point further, which was also eloquently articulated by my learned colleague, Advocate Lamin, to the effect that he read out the warrant of arrest. The date there is quite very important. Because there are no allegations to the effect that the applicant left to evade anything. There's nothing. In actual fact, the only time you find and locate evasion in the affidavit of the state is where they are saying for 11 months she evaded justice. Even to this date, the state had the opportunity to address it. Much as the state is critical about certain points, which I will address, which were left not addressed. This point of the state, the applicant evading justice for 11 months, unsubstantiated, even to this day.
If I may get clarity, I'm not disturbing. Are we still replicating? Because now it would appear that my learned friend is repeating their submissions. And the state never made any submission regarding warrant of arrest and 11 months, not in my address. So what he is replicating, we should be careful not to repeat our arguments that are already in court here. Unless, I'm not disturbing here, you can continue, but I just wanted to make sure I'm in the right court.
Not in the right court, in the right proceedings. Your Worship, in reply, indeed, I'm replicating. Now, when you replicate, you deal with those aspects that you didn't deal with, but the interconnectedness of the facts calls for one to piggyback and point out where to locate certain aspects that we are basing our argument on. For instance, just to assist my learned colleague, we are mentioning, we are addressing the issue of applicant having left the country, having not explained herself as to why she left, how, and all of that. And we are saying, these are the facts. And inevitably, one would have to refer this court to avoid a situation where the court gets to be confused as to the direction we are taking. To say, Your Worship, this point is backed up by that particular point. So in that way, with due respect to my learned colleague, that's replication, and I know how to replicate. All that I'm trying to do is to give context to the issues that I'm replicating to.
And I accept that.
As the court pleases. I remember during my early stages as a legal practitioner, that was the tactic that we used to employ to disrupt the chain of thought. So apologies, Your Worship. I was a bit distracted, but I'll gather my thoughts and proceed accordingly. Okay, Your Worship. Your Worship, touching on the issue of flight risk. If we're saying to this court there was no warrant of arrest, which becomes a sore point to a large extent, there was none. There was no reason why for the applicant to leave. And if there was no reason for the applicant to leave, there is no reason to doubt her evidence in as far as the manner in which she left the country. The state again reintroduced a point around the nationality of the person who's going to reside with the applicant. And the state creates a certain nexus, which is highly problematic. It says, look at the nationality. Something is wrong here. I smell a fish. Can the state really get to that level? Can we get to a court of law and speculate that there are similarities here. By the way, Section 9 of the Constitution is quite very clear. It's an equality provision. All are equal before the law. Is this not discriminatory? That the state is now diverting the attention. The issue here, Your Worship, is the alternative address. And the person that is amenable to accommodate the applicant is actually, and this is what my learned colleague, Advocate Lamini, indicated, a medical practitioner under the employ of this South African government, who, by the way, the state, through the state, is now a permanent citizen, she holds a permanent residence. She's a permanent resident. But the state keeps on going back, tracing her roots. For what purpose? The state should be saying she is not staying there. If in the absence of any argument to the contrary, I submit with respect, Your Worship, that this evidence of the applicant should be accepted. There's no reason to do anyhow. Your Worship, by the way, the state seems to suggest that for one to be a correct candidate to be admitted to bail, you need to have a fixed address. Unless I would not have located the rationale behind introducing this point. But our law is settled in that regard. Otherwise, people with no address, street kids, would not be eligible to be admitted to bail. And that will be discriminatory, and that would be unconstitutional. Where we are, what we say is that there is a confirmatory affidavit, and that confirmatory affidavit, by the way, annexed a very important instrument there. The utility bill from ESCOM, which the state tries to bring some comparison with regards, as if, Your Worship, the state suggests two wrongs makes a right. We did not comply with the issues pertaining to some of the evidence which I'll deal with now, and you also didn't. So let's just dust off and move on. That's not as easy as that. The reliance of the state in respect of the downloaded photographs are concerned. The law is settled. The Electronic Communications and Transaction Act, ACTA, is quite clear. And ACTA deals with data, admissibility of evidence that is produced in that form. And if the state had an issue with that, with the defense using the utility bill that is a copy, the state, by the way, the machinery that they have now, it indicated that it shows the efficiency of machinery. They could have authenticated it, but was that necessary? There is an affidavit, and that was the end of the issue regarding the applicant having to get an alternative address. Your Worship, the Section 66A leg of it refers to, and it says, in considering whether the ground in subsection 4B has been established, the court may, where applicable, take into account the following factors, namely the emotional, family, community, or occupational ties of the accused to the place at which he or she is to be tried. There's no mention in there. The state is saying She has siblings. She has parents. Why is she not staying with the parents? To the extent that the applicant says, I have an alternative address. That should be the end of the inquiry. Nothing more. As to who she would be staying with, it's really, I don't want to say neither here nor there. I will say it is immaterial. Your Worship, I wouldn't want to get to the space of personal attacks, this and that, but I struggle to locate personal attack on the affidavit of Colonel Flyman. I tried in vain to locate. And it would seem that Colonel Flyman's affidavit is really captured in a manner that is so respectful and all of that. But my learned colleague pointed out a very offensive word that is used, eloped. And no one is saying anything about it. The state is not saying, but yes, I see the Colonel Flyman here meant to say this and that. So I would submit, Your Worship, that in as far as Colonel Flyman's evidence is concerned, particularly around whether the applicant left voluntarily or not, it's not addressed. Whether or not when she came here, she should have told Colonel Flyman that no, she will not be staying there. She wouldn't have known where she will be staying anyway. She was going. She was under arrest, and she is not saying she gave me another. She gave that 22A address, and that's the end of the inquiry. Your Worship, I am inclined to deal with Section 28 of the Constitution, because it's a point that was sharply raised by my learned colleague for the state. Now, it is common cause that the applicant is a primary caregiver. This aspect is not disputed. All that the state is doing is to cast aspersions on it. If you are a primary caregiver, why did you leave the country? Now, Your Worship, I will refer the court to the probative value of an applicant who comes before court and indicates that I'm a primary caregiver, and how the courts deal with this. She has 2 minor daughters. I thus contend that this court is enjoined to consider the interests of her children, particularly with reference to Section 28(1)(b) of the Constitution. And this refers to the right of a child to parental care. And this should also be read with Section 28(2) of the Constitution. In other matters, this point alone was considered to constitute exceptional circumstance. And we know that exceptional circumstance in proceedings of this nature calls for a higher test. But this current fact was accepted to form part, to be to constitute exceptional circumstance. So, Your Worship, I hope I've dealt with expansively with the assertion that the state, or rather the defense, didn't challenge the veracity of evidence and allegations contained in the affidavit. I've dealt with that. The fact that I say during the proceedings in future, I intend to plead not guilty. I'm challenging this. I'm actually putting the state to the proof thereof. Is that not sufficient for purposes of this? I think I submit it is sufficient, Your Worship. Your Worship, it will be remiss of me not to deal with state versus Lamini, yes? When dealing with this, Your Worship, this point, I'll submit that it is wrong to subordinate the constitutional standard of interest of justice to the provisions of the statute. The statute must be interpreted in light of the Constitution. When that exercise is properly conducted, one must bear in mind that the interest of justice dictates that the purpose of bail provisions is to ensure that the attendance of an accused in his or her trial is not compromised, and that an investigation into the alleged crime is not hindered. This touches on section 64B as well as C. Now, with reference to State versus Lamini, the Constitutional Court held in paragraphs 4, Your Worship, paragraphs B, C, and D, and this was in contradistinction to paragraphs A, that you need to be directed at protecting and promoting the integrity of the investigation and presentation of the case in respect of which the detainee has been arrested. Those are undoubtedly the primary and most commonly expressed objective of the pre-trial detention. Just to preserve, to ensure that whatever I want to use against the applicant, against an accused person, has been preserved. It has not been hindered. My investigations are going to be are such that they are not interrupted, interfered with in any way. That is the barometer that is to be used. The interest of justice in regard to the granting or refusal of bail. Therefore, they just focus primarily on securing the attendance of the accused at trial and in preventing the accused from interfering with proper investigations and prosecution of the case. Your Worship, that's succinctly what legislature requires of us in proceedings of this nature. Nothing more. I submit, therefore, Your Worship, that the applicant, should this court find that the schedule under which she is charged falls under Schedule 5, that she is discharged. The honors bestowed on her on the scale of balance of probabilities that the interest of justice permit the release of the applicant on bail. Your Worship, that will be my address in as far as replication is concerned. May I just check with my colleague quickly? As the court pleases, Your Worship, my learned colleague has just pointed out some of the facts which were omitted in my address. With your leave, may I just address this and finish off and conclude? Your Worship, the state mentioned an issue around their bona fides in terms of how they couched their evidence and on that affidavit, that some of these factors were favorable. She's married, a married woman, that's a favorable point. But who eloped? Contradiction. But at the same time, the state alleges that we favorably put in the issue around the applicant having businesses or being a director. We did so to try and show that if she is to get out or be admitted to bail, she has economic interest. This is my learned colleague testifying from the bar. It's not in the affidavit. In the affidavit, all we know is these are the companies. They are taking it further. These are the addresses of the companies. It left the defense to even speculate in terms of what could be the relevance of this. We submit that was superfluous for the state to even put those factors. But we also submit that those factors were actually placed there to try and show different addresses. Now that the defense attacked those modalities, state changes and introduces something that is not part of their evidence. Your Worship, I've dealt with the issue around whether of the timing in respect of, and the choice, by the way, in respect of the applicant to lay charges or not. And in my submission, I say, Your Worship, with respect, that choice of the accused to or not to open charges, that choice cannot evaporate at some point and tender the applicant not to be legally allowed if she was to make that choice. But can that act or omission be then used to call on you to draw an inference on such a conduct? And can that suggest that applicant in any way could not have been coerced? There's no basis in law. Even on their facts, there is no basis to suggest that. So I submit, Your Worship, that this assertion by the state is misplaced. But in closing, there is a contention that is so patently misdirected, dealing with the pending litigation where the applicant challenged the lawfulness of her disguised extradition. This is not the proper forum to discuss it, or rather to debate this point, Your Worship. But since it emanates from my learned colleague's submission, I'm inclined to give a perspective. The argument that the applicant's posture to attack or to challenge her unlawful arrest, which she called that she was abducted and kidnapped, blindfolded, whisked away into an airport. It is so legally flawed to even suggest that she's challenging that arrest for her to be returned to Tanzania. Where does the state find this assertion from? It's not in the papers of the applicant here. It's not in the papers of the applicant in the pending litigation. All the applicant is saying, the prayers she's looking for is the proceedings to be declared a nullity. Nowhere has the applicant ever made any request or demanded to be taken back to Tanzania. That argument is legally flawed. That's my submission, Your Worship. And to this end, it seeks to suggest that if she is to be released, she will go to Tanzania. For what purpose? In actual fact, Your Worship, the state makes allegations about certain affidavits which suggest that the applicant is dishonest, she lied under oath. In all these charges, unless I miss something, I don't know if there is a perjury charge there. But that being the case, she has not been convicted of that. The state is calling the court to take judicial notice of the fact that is still to be decided. The fact that the applicant says, I'm going to plead not guilty, and I'm not disclosing the basis of our defense, does not give the state a free, I nearly say free right, but just the latitude to make allegations that this is a case that has, or rather that the applicant has been convicted of fraud, that she lied under oath. That is part of evidence that is going to be presented before this honorable court. I think I've touched on the fact that the applicant has assets in any event worth 1 million. Yes, I think we've dealt with the other aspects, Your Worship, particularly with reference to the fact that the flawed argument around whether the accused, the applicant, stayed in that address that she mentioned to the investigating officer legally or not. Advocate Dlamini dealt with that. The fact that the investigating officer confirmed that in his affidavit that at some point in March, he has information that the accused
State at that address. And such occupation
of those premises went beyond even the period that he mentioned in the affidavit to have been a period which meant the affliction of the lease agreement. Beyond that, one cannot even claim that it's tried law that lease agreement, unless it's so prescribed by law to be reduced into writing. There's so many lease agreements that run on month-to-month basis, whatever the case might be. But that argument is also legally flawed. Your Worship, this brings me to the end of my submissions, unless the court has some other aspects emanating from my address. I'm at your disposal, Your Worship, to address it. I know, Your Worship, I keep on saying final, last. It would seem that my address is semi-final, quarter-final, but this time around, my learned colleague, and I've indicated to my learned colleagues that this is now final. The issue on bail conditions, section 60, subsection 12. I think I addressed that issue. It will cure any concerns that the state will have in respect of aspects of section 60, subsection 4b, that there is a likelihood that if the accused was to be admitted to bail, will attempt to evade his or her trial. That brings me now, Your Worship, to the end of my replication, as the court pleases.
Thank you, Worship. 20-4. I want to believe that the issue of the next date has already been canvassed in chambers, and we are agreeable that for judgment purposes that the matter be remanded until the 11th of September, next week, Monday, 9 o'clock. She remains in custody until otherwise pronounced by the court. Thank you.
When I agreed to Monday, I didn't know that it's the 11th of September. But that being the case,
Is it your birthday?
11th of September.
Is it your birthday?
No, it's the 11th of September. Yes, but that being the case, Your Worship, the arrangement is suitable. The date thus is confirmed, as the court pleases.
As if that then concludes our round for the day. There's always lightning. Yeah, madam, I know what you want. I don't have the other. As please the court, Your Worship, the 4th day of September 2023, State Court Case number 20A113/2023 is the matter against Nandipha Magudumani, presiding judicial officer, Mr. Laja, appearing for the state SS Matuku, the court interpreter, Mr. Makala, and the defense is Mr. Machini Mutou. The court shall recall that Advocate Franz Lamini placed it on record that he's not available today, but that Mr. Mutou will be taking over. Your Worship, we adjourned at a stage where the defense was busy addressing you. I want to request that Mr. Mutou first confirm his appearance, and just after that and before he proceed with his address, the state would want to address the court on one aspect. As a pleasure.
As please the court, Your Worship, I confirm that I appear on behalf of the applicant in this matter. Your Worship, I also confirm the arrangements in as far as taking over further submissions to this court is concerned, that I will be addressing the court on some of the aspects emanating from the heads that were submitted to you as a court places.
Just before then, I wish to confirm that as per my undertaking, I made an undertaking to provide the defense with my heads by the 1st of September. But I wish to confirm that immediately when we adjourn on the 30th of August, I delivered a copy of my address to Mr. Mutou. And I also wish to say, in my absence, I also requested my colleague, Mr. Letaba, to deliver same to the magistrate in chambers. And that was done on the 31st of August, according to my information. If Mr. Macron can confirm receipt.
May it please the court, Your Worship, I acknowledge receipt of the submissions by the state as alluded. Your Worship, similarly, I would also like to confirm adherence to the directive of this court in as far as submission of or delivery of the heads is concerned. Same was indeed delivered to the state on Friday, the 1st of September, as the court pleases.
So confirmed, Your Worship.
Thank you. Confirm that I received in chambers a copy of states agrees in the course of the application.
As it pleases.
As the court pleases.
There's an aspect that I canvassed with my learned friend just before we started. The court shall note that in the beginning of these proceedings, both the state and the defense agreed in terms of the applicable schedule. That was Schedule 5. And the matter has since proceeded in terms of that agreement. But the court shall note that only during his address, Mr. Tamini played on the aspect of a schedule. And he gave reasons for that. I have since obtained a written confirmation in terms of Section 60, 11 capital letter A of the Criminal Procedure Act 51 of 1977, a copy of which was hand-delivered to Mr. Mutou, wherein the DPP, in terms of that section, confirmed that this is indeed Schedule 5. I wish to hand this over to the court, and if no objection from the defense.
As it pleases the court, Your Worship, I confirm that I received this notice from the Director of Public Prosecutions, Free State, in as far as the schedule of this offence is concerned. Your Worship, receipt of this or acknowledgement of delivery of this notice should not in any way, shape or form be misconstrued to be a concession on the part of the defense in as far as the argument is concerned relating to the schedule. Your Worship, I would not take this further when I have the opportunity to do so at a later stage as a court pleases.
Confirmation in terms of section 16, subsection B, A, subsection A of the Criminal Procedure Act, and it is marked as exhibit.
In terms of my records, the last exhibit was H, and that is the written submission by the applicant. No, it was the affidavit. H. Then there was
J was also received an exhibit. You can just go back to the exhibit itself.
yes. I think the written address by my learned friend was Exhibit I.
And then
J.
Please note this exhibit K.
As it please the court, yes.
As it pleases the court, Your Worship.
Joseph.
Can I just indicate what is written on this confirmation? It is issued by Affidavit Nandipha, the Director of Public Prosecution,
That's correct, Joseph.
indicating and confirming that the applicant before court, Ms. Mabulani and 11 others, will be arraigned on inter alia 4 counts of contravening Section 3 of the Corruption Act, and that for the purposes of bail proceedings, corruption falls under Schedule 5 of the Criminal Procedure Act as it involves more than 500,000, or it involves amounts of more than 100,000 if it's alleged that the offence was committed by a person who is syndicate acting in the execution of criminals or collaborators. So that this is what is contained.
As it please the court, Joseph. Yes, can I, with the permission of the court, can I ask that we swap seats with Mr. Mutlou? He indicated that he would need a podium, and we went around the whole building to try and get him a podium. Unfortunately, they are all fastened like this, they can't move. So for his address, can I allow him then to address you from here? As it pleases the court.
logged out of this respectful anything. I'm just trying to work on my laptop and I've got some
That's understandable, Your Worship. I must also indicate that it feels a bit awkward that I'm standing on the other side of the fence. I hope this would not really go down to even impact on my address, but I still appear on behalf of the applicant, Your Worship. Your Worship, I think what one is required to do in this bail application, take into account that this is a continuation from the address that was presented by Advocate Lamini on the 30th of August 2023. In avoidance of regurgitation of some of the aspects which were eloquently articulated and dealt with by my learned colleague, one would just to have a structure and framework of my address, point out salient issues emanating from this address of my learned colleague. Your Worship, you would note that our address commenced with the preliminary issues. Now, I intend to address the court under the following topics. My learned colleague dealt with preliminary issues pertaining to the schedule. I'm not going to delve deeper into those issues, except to say, in the light of the notice that has been dispatched by the DPP's office, I'm inclined to provide a brief response thereto. Your Worship, the next topic that my learned colleague dealt with related to the charges preferred against the applicant. And he then further dealt with the topic around the state's case. And he spent quite some time dealing with the issues emanating from the state's case. From time to time, Your Worship, I would piggyback on some of the issues emanating therefrom. The topic that I will address this court on will be the applicant's case, and thereafter I will address the court on the absence of the provisions of section 60 subsection 4 A to E. So in essence, I'll deal with bail legislation in respect of this matter. Your Worship, I will then move to deal with the applicable law, inclusive of case law, in demonstrating to this honorable court that the interest of justice exists in this matter,